The letter landed on my desk at 9:03 a.m. on a Tuesday. It said I was being transitioned out. 20 years. Gone in one paragraph. But what Richard Holt didn't know, what he couldn't have known, was that I had been waiting for this exact moment for 3 years. My name is Eugenio Morales. I am a 44-year-old patent attorney and chief innovation officer. I built Holt Technologies from a garage operation into a $340 million company. I wrote the patents. I filed them. And I made sure, very quietly, very deliberately, that my name was on every single one. Richard Holt was the face. I was the engine. For 20 years, that arrangement worked. He shook hands at galas. I solved problems at midnight. He gave speeches. I invented the systems those speeches described. We had a deal. Unspoken, but real. Then his son, Derek Holt, graduated from a second-rate business school. Suddenly, everything changed. Derek started sitting in on my meetings. Then leading them. Then replacing me in email chains. I watched it happen slowly. I didn't say a word. I just started building my exit strategy instead. The first thing I did was call my attorney, Sandra Voss. She was not warm or friendly. She was precise and ruthless. Exactly what I needed. Pull every patent filing from the last 20 years, I told her. Cross-reference them with my employment contracts. She called me back in 2 days. Eugenio, she said, and I could hear the smile in her voice. You own 41 of their 47 core patents outright. The other 6 are jointly held. Richard signed nothing that transferred those rights. My hands were shaking. Not from fear. From the satisfaction of knowing the trap had already been set years ago. Here is what Richard never understood about patents. A patent belongs to the inventor, not the employer, unless there is a specific written assignment. My early contracts with Holt Technologies were sloppy. Richard was cheap with lawyers back then. He never made me sign a proper IP assignment clause. By the time his lawyers cleaned up the contracts, I had already filed dozens of patents independently. Quietly. Correctly. Richard spent 20 years building a company on a foundation he didn't own. He just didn't know it yet. And I had no intention of telling him until the moment it would hurt the most. Derek Holt called me personally the week after the letter. He sounded nervous, which I enjoyed. We want to make this transition smooth, he said. We're offering a generous severance. 60 days. Full benefits. I let the silence stretch for 5 full seconds. That's kind of you, Derek, I said. My voice was flat. Controlled. Let's schedule a formal exit meeting. I want everything documented. He exhaled with relief. He thought I was going to be cooperative. That was his first mistake. His father had taught him how to win. He hadn't taught him how to read a predator. My chest was tight during those 2 weeks. I won't pretend otherwise. 20 years is not just a job. It is your identity. Your mornings. Your sense of purpose. I had poured everything into that company. I had missed vacations, birthdays, weekends. I had solved crises at 2 a.m. while Richard slept soundly. The rage was real. It sat behind my ribs like a hot stone. But I had learned something over 44 years of life. Rage without direction is just destruction. Rage with a plan is a scalpel. I picked up the scalpel. Sandra filed the first legal notice on a Thursday. It was not a lawsuit. Not yet. It was a formal IP ownership claim on 41 patents currently in use by Holt Technologies. The document informed the company that any continued commercial use of those patents without a licensing agreement constituted infringement. It was sent to Richard's personal attorney, the company's general counsel, and, this part was deliberate, the firm's 3 largest institutional investors. I wanted the right people to see it before Richard had time to spin the narrative. Sandra told me the general counsel called her within 40 minutes. He was not calm. Richard called me himself that evening. The composed, polished voice he used at investor dinners was gone. What is this, Eugenio? He said. His voice cracked on my name. This is a legal notice, Richard, I said. Your lawyers will explain it. You can't own those patents. You built them on company time, with company resources, with no assignment agreement, I said. Your 2003 contracts are very clear on that. Or rather, very unclear. That ambiguity belongs to me now. The line went quiet for 4 full seconds. Then he said, I'll bury you. I almost laughed. You already tried that, I said. With a letter. Remember? Sandra requested an emergency injunction the next morning. The argument was simple. Holt Technologies was actively generating revenue, $340 million annually, using patents they did not legally own. Until ownership was resolved, they could not continue selling, licensing, or developing products based on those patents. The judge reviewed the filing. She was not impressed with Holt's counterargument, which was essentially, we assumed we owned them. Assumption is not law. The injunction was granted within 72 hours. Holt Technologies was ordered to halt sales on 3 of their flagship product lines immediately. Derek called Sandra's office and was put on hold. The investors moved fast. That was predictable. When 3 flagship products go dark under an IP injunction, institutional money doesn't wait for explanations. 2 of Holt's largest shareholders requested an emergency board call. Richard was forced to disclose the full situation. I heard later, from someone still inside, that Derek sat at that board table and said nothing for the first 40 minutes. Richard tried to frame it as a disgruntled employee dispute. One of the board members, a sharp woman named Patricia Osei, asked one question: did we ever obtain a signed IP assignment from Mr. Morales? The room went silent. That silence was worth 20 years. Sandra and I sat across from Richard and his legal team 8 days later. The conference room was cold and expensive. Richard looked older than I remembered. Derek sat beside him, jaw tight, eyes moving to his phone every few minutes. Richard's lead attorney, a man named Gerald Price, opened with a number. It was an insulting number. A go-away quietly number. I looked at it. I looked at Richard. Then I slid it back across the table without speaking. Sandra leaned forward. Mr. Holt, she said, my client isn't here to negotiate pennies. Let's talk about what this company is actually worth without its core IP. Gerald Price tried 3 different legal arguments over the next 2 hours. The first was work for hire. Sandra dismantled it in 4 minutes using the actual contract language. The second was implied assignment by conduct. Sandra had case law ready, 6 precedents, printed and tabbed. The third was estoppel, that I had behaved as though the company owned the patents for 20 years. Sandra smiled at that one. Mr. Morales never licensed those patents to Holt Technologies, she said. He simply didn't enforce his rights yet. There's no legal deadline on deciding to do so. Gerald stopped talking after that. He started writing notes to Richard instead. Derek broke first. He leaned forward and pointed at me. You're doing this out of spite, he said. His voice was louder than the room called for. You're burning down 20 years because your feelings got hurt. I looked at him. I kept my face completely still. Derek, I said, I'm doing this because I own the intellectual property that generates 60% of your revenue. Feelings have nothing to do with it. He opened his mouth. His father put a hand on his arm. Even Richard knew that Derek had just made things worse. The investors on the board were already asking if Derek was fit to lead. He had just confirmed their doubts. Sandra presented our terms that afternoon. They were not gentle. We were not asking for a settlement. We were asking for a licensing agreement, structured over 15 years, that would pay royalties on every product built using my patents. The rate was 18% of net revenue. At current numbers, that was approximately $61 million per year. Gerald Price turned the color of paper. Richard stared at the ceiling. Derek pushed back from the table and said, "This is extortion." "No," Sandra said calmly. "Extortion is illegal. This is property law. Your client used someone else's property for 20 years without paying for it. We're correcting that now." The board removed Derek from the interim CEO position 4 days later. It was not announced publicly, but it didn't have to be. Patricia Osei sent Sandra a brief email that said only, "The board is ready to discuss resolution." That email told me everything. Richard had lost control of his own company. The son he had groomed to replace me had lasted less than 3 weeks before collapsing under the pressure. I read that email twice. Then I put my phone down and ate my lunch in complete silence. It was the best meal I had eaten in months. The formal negotiation took 11 days. Richard's team tried to reduce the royalty rate. We held firm. They tried to exclude future products. We held firm. They tried to cap the total payout. Sandra laughed, professionally, but she laughed. In the end, the agreement was close to our original terms. 17% royalty over 12 years. A lump sum back payment for the prior 3 years during which the injunction research had been active. Total value of the deal, just over $800 million across the life of the contract. Richard signed with his jaw clenched so tight I thought his teeth might crack. Sandra handed me my copy of the signed agreement in the parking garage afterward. She didn't celebrate loudly. Neither did I. We shook hands. That was enough. I drove home in silence, thinking about the exact Tuesday morning 3 years ago when I had first realized what Richard was doing. When I had first seen Derek sitting at the head of a meeting I had organized. I had gone home that night and called Sandra. Not to cry. Not to vent. To start building the case. Every move after that had been deliberate. Every document. Every delay. Every silence. All of it pointing to this moment. Richard Holt issued a company-wide memo the following week. It was vague. It referenced a strategic IP licensing agreement and an exciting new phase of partnership. He did not mention my name. He did not explain what had happened. But everyone inside that company knew. My former assistant texted me 2 words, "They know." The stock dropped 4% on the day the agreement was filed publicly. Not catastrophic, but visible. A permanent mark on Richard's record as a founder. A reminder that he had built his empire on someone else's work and had never bothered to make it his legally. That mark doesn't wash off. Derek Holt posted something vague on LinkedIn the following week about exploring new opportunities. The comments were full of people wishing him well. None of them knew. I didn't correct them. I had no interest in public humiliation. Public humiliation is for people who need an audience. I didn't need one. I needed the signed contract, the royalty schedule, and the wire transfer confirmation that arrived in Sandra's escrow account on a Friday afternoon. The first payment, covering 3 years of back royalties, came to just under $180 million. I looked at the confirmation number for a long time. Richard called me one last time. I almost didn't answer. I picked up on the 4th ring. He didn't say hello. He said, "I want you to know I never thought it would end like this." I said nothing. He continued, "You were the best person I ever worked with." I let that sit in the air between us. Then I said, "I know, Richard. That's exactly why this worked." I ended the call. I did not feel sad. I did not feel triumphant. I felt the clean, quiet satisfaction of a plan that had been executed without error. That feeling is better than any emotion. It lasts longer. The company still operates. The products still sell. My name appears in no press release and no headline. But in every royalty payment, in every quarterly check that arrives on schedule, the truth is written in numbers. Holt Technologies did not survive because of Richard. It did not survive because of Derek. It survived because of 41 patents filed by one man who worked quietly, planned carefully, and waited with infinite patience. Richard built a house. I owned the foundation. When he tried to put someone else in charge of the house, he forgot to check the deed. That oversight will follow him for the next 12 years. There is a specific kind of victory that requires no celebration. No speech. No moment in front of a crowd. It lives in documents. In account balances. In the silence of a conference room after a signature. I had spent 20 years being invisible. The engine behind the face. I had accepted that arrangement because I believed in the work. When Richard decided the work no longer needed me, he made a single, catastrophic miscalculation. He assumed that loyalty and ownership were the same thing. They are not. Loyalty is a choice. Ownership is a legal fact. And legal facts do not care about feelings, history, or a man's ego. I did not take a vacation. I did not throw a party. On the Monday after the agreement was signed, I opened a new company, filed the incorporation papers, set up the IP framework correctly from the first document. No ambiguity, no gaps, no assumptions. I had spent 20 years building something for someone else. That chapter was finished. The next one was already written in my head. Not because I was angry, not because I was trying to prove something, but because this is what I do. I build. The difference now is that everything I build belongs entirely to me. Richard Holt will spend the next 12 years writing royalty checks to the man he tried to discard with a one-paragraph letter. Derek Holt will spend those same years explaining to interviewers why his tenure as CEO lasted 19 days. The company they tried to hand off like a family heirloom is now legally tethered to me until 2037. Every product, every sale, every dollar of growth funds my next chapter. They thought they were replacing me. They were actually handing me a 12-year revenue stream and walking away like it was their idea. It wasn't their idea. Nothing important ever was. Because remember, emotion is just noise. A plan is a finish line. The moment you stop reacting and start building your case, the game is already over. They just don't know it yet. If you enjoyed watching this justice unfold, please like the video and leave a comment below telling me what you thought. And if you haven't subscribed to Revenge with Monroe yet, hit that notification bell so you never miss the next move. Thanks for watching, and I'll see you in the next one.